The modern internet is built on user-generated content, comments, reviews, tweets, and videos. For 30 years, Section 230 of the Communications Decency Act was the shield. It said, if a user posts something illegal or defamatory on YouTube or X, those companies are not the publishers. They cannot be sued. But in 2026, the shield is breaking. In the US, the Supreme Court has redefined what counts as moderation. In the EU, the Digital Services Act, DSA, has rewritten the rules entirely. Today, we're looking at why the 26 words that created the internet are dying, and what the US and EU are doing to replace them. In the old world, a newspaper was the publisher. If they printed a defamatory letter, they could be sued for it. But the telephone company was not a publisher. If two people used a phone to plan a crime, you couldn't sue the phone company. The original legal debate was, is an internet platform a publisher or a distributor? If it was a publisher, it would never moderate, because if you touch one post, you are responsible for all posts. Section 230 solved this with platform immunity. It said they are distributors, even if they moderate. This incentivized platforms to filter spam, hate speech, and illegality without fearing a lawsuit for every mistake. For decades, lower courts gave platforms a broad shield. But the US Supreme Court has spent the last 5 years narrowing it. In a landmark 2025-2026 ruling, the court drew a new line, the algorithm exception. The court ruled that while Section 230 protects a platform from the original post, it does not protect the platform's decision to algorithmically amplify that post. If your algorithm actively pushes harassment, you can be sued as a publisher of that amplification. Meanwhile, across the Atlantic, the EU didn't wait for the courts. The DSA, now fully in force, took the Good Samaritan idea and gave it strict legal teeth. The DSA introduces a notice and action mechanism. Once a platform has knowledge, a formal notice, of illegal content, it must act fast to remove it. If it doesn't, it loses its immunity shield for that specific piece of content. For VLOPs, like Meta, TikTok, or X, the DSA demands annual, expensive risk assessments. These companies are legally liable if their system causes systemic harm to democracy or mental health. So, where does this leave us in 2026? The uniform, blanket immunity is over. We now have two versions of liability. US platforms are adjusting their algorithms to reduce liability risk, making feeds blander. EU platforms are hiring massive teams of human moderators to meet DSA deadlines. The age of we are not publishers is dead. The question now is, what kind of publisher will these trillion-dollar platforms be? Thanks for watching. See you in the next analysis.